More DNA was found at the scene under Maddie's fingernails. The defense wants all this DNA evidence thrown out, so clearly Bryan Kohberger is guilty of the crime he was charged with. Clearly he's the individual who passed away 4 University of Idaho students. Well, that's what the headlines are saying. I have a different take and a different explanation, so all that being said, everything's alleged. Welcome to The Point. Let's get to it.
Which brings us to the first question in our investigation. And it's all about this DNA. What does this DNA prove? What does it show? What does it demonstrate? Got to get to the bottom of this. Joining me, former detective, host of The Interview Room with Chris McDonough. Chris McDonough is with us, and laboratory director for Pure Gold Forensics. She has more than 20 years of experience in DNA analysis, forensic DNA expert, joining us from a lab where she works, Susanna Ryan. Great to have you both here. Susanna, I want to begin with you. 3-person mixture. What does that mean? What are the challenges? What are the limitations? What can you get when you have a sample that is a 3-person mixture?
A lot of that's going to depend upon the quality of the mixture. So it sounds like, we have Madison's DNA, which is not surprising, and then at least 2 other contributors. Now, looking at this motion, the fact that multiple individuals were listed as sort of inconclusive tells me there's probably not a whole lot of data available for comparison.
And yet they had all this availability to test the DNA found on the sheath, which was reported to be a partial sample of transfer DNA, or touch DNA, however you want to phrase it. And a huge question a juror is going to have is, how are they able to do so much with the partial sample on the sheath? Why was it only a single source of DNA found on the sheath when they didn't test the glove, they didn't test the stair rail, and they apparently don't have enough to test within these fingernails? I mean, a rational person is going to ask the question, if you could do all this for a partial sample of DNA found on the sheath, why can't you do that for all the DNA found under the fingernail? It's clearly a part of the crime scene.
So it's probably a low-level mixture. Now, that could mean that the DNA arrived just through casual contact. As a person goes about their day, they can pick up DNA under their fingernails or on their fingernails, or it could mean something more.
And that's the big question with the sheath that a lot of us have raised. Transferred DNA is very easily picked up from one object to another. It does not necessarily mean an individual touched that object. A lot like she said, you can grab something with your hand and have DNA of another individual underneath your fingernails. Those rules and laws apply to sheaths as well. The story as it stands isn't necessarily cut and dry. Now, does all this mean Bryan didn't commit this crime? No, it doesn't. But the headlines running around with this particular story saying this 100% implicates him isn't a fair take either.
I want to go to more information that we have from this motion, which I think will explain a little bit here. The data from that sample was, and then they redact the word, as to the suspect, the accused. Miller testified that the redacted word there, we think this is the redacted word, inconclusive, right? So they say in the next sentence that Miller testified that inconclusive means that an analyst is blank, again, redacted. I'm taking from that the redacted word may very well be inconclusive. Miller went on to explain that the likelihood ratio for the suspect, and then that's redacted. The suspect's inconclusive LR likelihood ratio is similar to almost every other person for whom an LR was generated, and focusing on his inconclusive likelihood ratio would mislead the jury, in that it applies that LR means that the suspect's DNA might be present in the sample.
And that's the reason of the motion. That's why they don't want any of this included. And you'll hear what the defense did with this sample in just a minute. But the state is 100% going to say, hey, we tested Maddie's fingernails. We had 3 samples found on Maddie's fingernails. And the results were inconclusive. Meaning we don't know if this is Bryan's DNA or not. And a juror, especially in the DP case, is going to heavily favor what the state says. They're going to believe the state more than they believe the defense. So it is much safer and much fairer just to exclude this altogether, since none of this really points to anybody. And if this does continue to be a DP case, which I believe it will, statistically speaking, the jury is more likely to vote guilty than not guilty. So the defense wants to get all this or as much of this thrown out as possible.
More importantly, the suspect has disclosed that through further independent lab testing, he is eliminated as a contributor to item 13.1.
And even if they did their own independent test with their own expert, it's not going to necessarily have much weight as what the state says, so it is much better to toss this out from a defensive perspective than allow it to be in. Their independent test excluded Bryan Kohberger. Now, if all this does come into trial, I understand that they can get up there and say, the state ran their test, they found it to be inconclusive. And we ran our test and it excludes our client. But once again, what does the common juror think when they hear the defense speak? Well, are they lying or are they believable? If you're preparing your defense based off probability and statistics, it is much safer for them to exclude all this than leave this in, even though they have something that says it excludes their client.
Okay, Suzanne, a couple more questions to you, then I want to get to Chris. So, the LR, the likelihood ratio, what is that? What's the significance of that?
That is the way that we do statistics currently. And it is basically a comparison of two mutually exclusive hypotheses. So one hypothesis would be what we call the prosecutor's hypothesis, which typically is that the person's included in the mixture. And that is compared to the defense hypothesis, which typically is that person is not in the mixture. And the likelihood ratio tells you which of those hypotheses is more likely. So in this case, when we have what they're calling an inconclusive range, they're saying, I can't tell you whether this person is included or excluded. However, I think one of the issues that the defense has with this is that there are recommendations, sort of the scientific working group on DNA analysis methods, they've come up with a number of recommendations. And basically they say no matter what the likelihood ratio is, whether it's a small number in support or a small number supporting exclusion, you should still report that number. Instead, this laboratory apparently has a pretty wide range of inconclusive.
So make this make sense to me. Now they're saying that the suspect, the accused, has disclosed that through further independent lab testing, he is eliminated as a contributor. How could a different test now have seemingly a different result that actually eliminates his as a contributor?
Well, that's easy to answer, and I'll go on to give my comments on this before she does. The problem with DNA is that we believe DNA to be rock-solid proof an individual was at a place at a particular time. But when you're dealing with partial samples, mixtures, incomplete samples, and degraded samples, those analysts have to do stuff with that sample to make it readable. And that's where the human error in this particular situation comes in. That's why a lot of us have an issue with the FBI coming down to the state and saying, hey, look at Bryan, this is your tip, when all the work that they used to form this particular hypothesis has been destroyed or missing. The DNA gets manipulated all the time. It is not necessarily a conspiracy theory. We've talked about it before. You can go look at those videos. Genetic analysts make mistakes. Some genetic analysts intentionally make mistakes. This is a partial sample. If it were a full sample, it might be a different story, but that is why we have a problem here.
Is this just an interpretation of results, or is there different testing that could have been done? How could that be?
I think that probably the independent lab retested the sample and perhaps they were able to get a little bit more DNA from the sample. Perhaps their guidelines allow for them to eliminate a person at a certain less than 1 likelihood ratio versus this lab. So this independent lab may have done some additional testing, concentrated the sample, done something to be able to get a little bit better of a result where they can say he's excluded instead of the Idaho laboratory, which they're saying inconclusive, but reading the motion, it probably should properly be said as support for exclusion. They probably were in a less than 1 likelihood ratio level, which is actually support for exclusion.
The state is muddying the waters.
Chris McDonough, let me ask you, so what does this DNA prove?
Vinny, obviously DNA evidence would put somebody at a crime scene. However, when there is an analysis like this that comes back, inconclusive, it means the results aren't necessarily clear cut. So from an investigative side, that could be from a couple of reasons. I mean, like a sample was too small, maybe it was, degraded, maybe it was mixed up with other DNA, like in this case. So you couldn't get a solid match.
And yet you were able to do all this stuff with the sheath. That was a partial sample as well, but somehow you moved mountains and bridges to figure out who this supposedly belonged to, even though you destroyed the work, even though you violated an individual's rights. I understand that they didn't necessarily break the law because this was just a policy, but two wrongs don't make a right in this situation. Everybody okay with the FBI looking into databases without a warrant simply because they want this crime solved is heading down a slippery slope, and it's a huge problem. Partial samples are partial samples. If you were going to test one partial sample found on the sheath, you should have tested the partial samples found under Maddie's fingernails. I mean, that DNA technically a part of the crime scene. You should have done anything and everything you could to identify who that was, at least just to rule it out. I mean, the double standards within this story are becoming absurd. You have DNA found on a handrail that is the exact type of DNA you would think would be left at a crime scene. You have DNA found on a glove outside the home that is the exact type of DNA found at the crime scene. And you have this DNA under Maddie's fingernails, but you're not going to do anything with this particular DNA. Two of the samples don't meet the qualifications for CODIS because we just say so. And this DNA found under the fingernails just isn't enough for us to be concerned about. I mean, when individuals say they have a big concern that this is possibly a botched investigation, this is the stuff they're talking about. Now, did the state botch this investigation? No, we don't necessarily know that at this time, but I think there is some cause for concern here. At least that's just how I'm seeing it. Now, if you see it differently, you can let me know down in the comments below.
Well, basically, it's a shrug of the shoulders from the lab. And so as an investigator, you have to take that and say, okay, well, then we have to put that over here in the exclusionary column until we get some additional definitive evidence. And that's what they did by revealing it to the defense.
So, Susanna, the next question is, okay, if let's say he's excluded, or however we want to term it, right? It's interesting to hear it explained because a jury's going to have to understand this. Is there a way to take those the two samples that aren't her and to determine any information about the source of it, whether it's gender, race,
but you won't know how they came up with their conclusion.
You may be able to tell gender. So there are a couple of different markers that we look at that are indicative of males. So they're specific to the male. So we know, obviously we have Maddie, a female. If any of those other markers that are specific to a male pop up, then they can say there's at least one male present. But that would be about it. We don't use the DNA that we do in the forensic lab to do any sort of, ethnicity or racial background or, hair or eye color, any of that. That's all completely separate. So that would be the farthest we could go, is possibly saying that there's a male present.
And is there any other way to put it in a pool of potential people? Like, if you've got a sample like this, would you get enough information where you could run that information through CODIS and you may not get like one hit, but you might get thousands of hits? Does it work like that, or it doesn't really work like that?
So the samples that are eligible for upload to CODIS they cannot be too much of a mixture because we don't want to have thousands of possible hits to go through.
And when they swabbed Bryan's mouth and matched it to the DNA on the sheath, there is a significantly high chance that DNA found on the sheath is matching to that swab because it is a partial sample. The smaller the sample found means an increased likelihood it's going to match to more people. At least that's just how I'm understanding it. And what she's saying is accurate. You don't want to run all this stuff through a system because you're going to get way more hits than what you should. But they were fine doing it with the sheath though.
And again, kind of reading between the lines here, it sounds to me that the data is really low level and probably not eligible for CODIS. It's good for comparison
Nothing's
to
eligible for
other
CODIS,
potential persons of interest, but not for entry into CODIS.
All right, Susanna Ryan, I'm so glad that you're able to come on this program and help us explain this and help us understand this. Chris McDonough is going to stick around. Thanks so much, Susanna. Coming up next, so what does this DNA mean for the trial?
Honestly, none of this DNA is going to matter at all. That's just how I'm seeing it. Not the DNA found right here, not the DNA found on the sheath. This is a hugely circumstantial case, which means only one thing. Who can tell the better story here? And a lot like that commenter said, if the state can come up there and present their story without a lot of holes or be able to fill in a lot of these holes, the jury is more than likely going to find Bryan guilty of a crime. But if the defense is able to get up there and tell their story, and their story doesn't have a lot of issues, and their story has a lot of reasonable doubt, then that means Bryan's going to walk. There is no hard evidence here. Individuals saying there's all this hard evidence pointing to Bryan Kohberger being guilty is just so incorrect it's not even funny. It's a circumstantial case. Who's the better storyteller here? Is Bill Thompson going to be able to get up there, articulate his point of view clearly and concisely without having a lot of issues, and Taylor going to be able to get up there and shoot down all this and say, look, this is why our guy didn't do it? That is going to be the factor. That is going to be the difference. Touch DNA, transfer DNA, whatever you want to call it, transfers easily. It doesn't mean a whole lot. It does not place Bryan at the scene of the crime. Especially when you consider now you have all these extra DNA sources found at the scene and none of those point to Bryan as the suspect. But that's my take, and that's the fairest breakdown I can give. And if you enjoyed this in a more fair, open conversation, maybe check one of these videos out. Y'all be safe now.